Good morning.
Good morning, my lord.
Now we've got someone. God, good morning.
Good morning. Bright and early from London.
Yes, well, thank you very much for joining us at your inconvenience. We've got quite a lot to get through in an hour and a half. We don't have an agenda as such. And what I would propose to do, without expressing any preference as to the contents thereof, would be to take the claimant's skeleton argument of the topics raised there and deal with those, and then turn to the defendants.
Yes, and my lord, that is what I propose to do. And I don't know, I know you've been bombarded with pieces of paper, and I don't know what chance you've had to read what has been sent to you. And I know you're somewhat familiar with the case from the past. You will have seen that the first topic, which I think is logically the first topic, and the first topic that I raised in my skeleton, is the amendments to the pleadings.
Yes.
And I've covered that in some detail in my skeleton. You will then have seen that the only one of those that I think remains in issue now is what I consider to be a small amendment in relation to the deceit claim. So that has narrowed.
All right. Well, shall we zero in on that now then?
Yes, I think
I'll just seek confirmation from Ms. Ahmed. It is Ms. Ahmed.
It is
yes,
indeed.
yes.
It is, yes.
That there is this one remaining challenged amendment, and then we'll look at that and we'll get the amendments out of the way.
Grateful.
Do you agree?
Yes.
Yeah.
Yes.
Right, now I'm just going to, Mr. Kumar, I'm just going to get the file with the relevant pleading in.
Yes.
Yes. Where do I find the proposed amendment? Here we are, it's at tab 4 of file 1.
Yes.
Is it the particulars of claim, or is it in the reply, or where is it, the one troublesome...
It's in the draft. It's dealt with, in my skeleton argument,
Yes.
It's dealt with at paragraph 13 on page 5.
Yes.
And it's paragraph 45.1, 48 of the particulars of claim, and also of the amended particulars of claim, which are at divider 4 of file 1.
Oh, yes, I see. And so I should go to paragraph 45.1.
45, yeah.
Yes.
And I think that you will know that the claim is put as breach of contract, but also in deceit and by way of conspiracy.
Yes, I do.
And one of the bases of the deceit claim is that there was a deceit in relation to the question whether or not Repoint had an appropriate relationship with Narain Singapore, through which it could even conceivably, in principle, have settled the disputed trade. And the way that false representation was put originally, you can see at 45.1 in those words that have now been lined through. In other words, no account through which instructions could be given to settle trades in securities. And it was simply trades in securities generally.
Yes.
And at paragraph 48, there's a corresponding pleading in relation to the knowledge of Mr. Kumar, who is the third defendant. And the point was put in the same way, that he knew, or was reckless about, whether or not there was a relationship with Narain Singapore through which trade could be settled, was the way it was put.
Yes.
And the amendment which we have made is, in my submission, simply to narrow that. Rather than trade in securities, we say that the false representation was in relation to this trade in particular. In other words, that it was represented that there was a relationship that was capable of leading to the settlement of this trade. In fact, there wasn't, and he knew that and was reckless about whether that was the case. So I say it's a very slight change, and it's a narrowing in any event of the case, and it's not one, therefore, that causes any unfair procedural prejudice to the defendant. And also, as you'll have seen, or you can see in my skeleton, this is an issue which is traversed in the evidence, and I can just show you that quickly. You might wish to see it.
Yes.
In the second witness statement, Mr. Elliot Goodfellow, who's the principal witness for my client.
Yes. Wait a minute. Which volume? Which file is that?
That's at file 4.
Yeah.
Divided 26.
Yes.
Page 807.
Yes.
Page 808, actually, sorry. Paragraph 44.
Yes.
And perhaps you might just quickly read that yourself.
Read paragraph 44, yes. Okay.
Paragraph 44, what do you read?
Yes, I'll read it to myself. Yes. Yes, I've read that.
Thank you. And then in the witness statement of the second defendant, which is in file 5, divided 35.
Yes.
Paragraph 24 and 25, which are on 1294 and 1295.
I'll read those. Wait a moment.
Read those, I think,
yes.
is the best thing to do.
Yes, I've read those 2 paragraphs.
Yes, thank you very much. So really what I would say is that this is it's a narrowing of the case in the way that I've described. The parties have dealt with it. Essentially, it was understood by the defendants that what we were saying was, look, you were telling us that you had a relationship with Tavira, which was a relationship capable of settling this trade. In fact, that wasn't the case, and therefore you were deceitful to us, and it has caused us loss. And as I say, we've narrowed very slightly the way that that's put. The parties have understood what it was they were arguing about, and they've put that in their witness statement. And so, in my submission, the amendment now sought is one which ought to be permitted. It causes no particular prejudice or no unfair procedural prejudice to the defendant.
Yes, Ms. Ahmed?
Yes, indeed. My Lord, we would say that the amendment isn't as narrow as suggested by the claimant's counsel, and it does have serious legal and procedural implications. if I go back to the pleadings, the amended draft behind tab 4 of volume 1, you've been taken to paragraph 45
Yes.
of the amended pleading, but if I can invite you to go back to paragraph 43, which starts off the claim for deceit against first and third defendants. And the way it's been said that the representation that was made by email on the 30th of September that there was a commercial relationship between Repoint and Nomura through which such trades could be settled. That was the premise upon which the deceit claim was being brought. When one then turns to paragraph 45 and 45.1, whilst claimant's counsel says that the issue has been narrowed, the issue that we have is that there has been no way or nowhere in this pleading, which or the amended pleading, that is supported by any documentary evidence. Now, my learned friend has taken you to the witness statement of Mr. Elliot Goodfellow, the second witness statement, and you were invited to read paragraph 44 of that statement. If we can perhaps turn that up again.
Yes.
It's behind tab 26, volume 4, page 808.
Just give me a moment. Tab 24, yes, and...
sorry, tab 26.
I'm sorry, tab 25.
Paragraph 44, 808.
Okay, wait a moment. I'm nearly there. Yes. Do you want me to read that?
Well, you've already read it. You're
I've already
invited
read
to read
it.
it. Yes,
Okay.
you're invited
Yes,
to
that's
read
right.
it
I've
by
already read it.
Yes,
Quite
by Mr.
right.
Greenwood. And what we say is that this is the first time, so early this year, 13th of January 2019, this is the first time that the defendant is aware that, in fact, a claimant's representative, Mr. Goodfellow, contacted Nomura and asked Nomura whether or not it had settlement instructions. Now, firstly, we say that this is too late in the day, and clearly the claimant would have known when it first pleaded its case whether or not Mr. Goodfellow actually did.
Well, what are you objecting to, this witness statement or the proposed amendment?
Well, I'm objecting to the witness statement. I'm saying that there's no reasonable prospects of success, firstly, in terms of bringing this new case, and secondly, I'm saying that it has a procedural implication, because the reason why we say paragraph 44 appears is that when the premise of the deceit claim was, look, you don't have any relationship, the defendants produced in production documents to show that there was an account opened with Nomura, and therefore that gave an answer to whether or not there was a relationship with Nomura. When the claimants received that production, we say that they have now changed their case, and that change of case is as represented by Mr. Goodfellow at paragraph 44, where there is simply no evidence of any call being made, any correspondence between Nomura and the claimant, firstly, and secondly, this is a material fact that goes to the heart of the deceit claim. And if this is correct, then Mr. Goodfellow or the claimant would have known this at the time that they pleaded the case. And therefore we say that there is a procedural irregularity.
But as I read paragraph 44 at the moment,
Yes.
it's dealing with establishing the falsity. Mr. Goodfellow is relating what he's told by someone at Nomura over the telephone, and that person made it clear to me that Nomura Singapore had no instructions to settle the trade that I described to him. The person also told me that Nomura Singapore did not settle trades with third parties on behalf of their clients. They were a private bank. Now look, there are two elements here. First of all, there is the representation.
Yes.
And then the question is it false?
Yes.
And with the necessary mens rea.
Yes.
Now, what is pleaded and the subject of the amendment is that the amendment goes to falsity. The point had, repoint had no relationship with Numura through which instructions could have been given to settle the trade. Now, implicit in that is that the representation was that Numura had instructions which could have been given to settle the trade in question. And then the falsity is pleaded, that in fact they had no such instructions. Now, at the moment, I don't see why the fact that the defendants have produced documentary evidence to show an arrangement, so I call it that, an arrangement for the settlement of trades. I don't see why, at the moment, that means that this amendment cannot be allowed. It's true that it is, in a sense, I can see why you say, well, this is responsive to what they now have seen is the position. And they are shifting their ground accordingly. And this is rather new. We haven't had this refinement before. I follow all that.
Yes.
But the trial isn't until sometime off in the middle of March, as I remember.
17th of March, yes.
It seems to me that the case, as it's wanted to be pleaded, is reasonably clear. The question really is whether you're put at any unfair disadvantage, given the date set for the trial, for this refinement of the case to be allowed. Now, help me with that. I mean,
yes.
Where is the real prejudice in permitting this amendment?
We would say it's twofold. The first one is that where the defendants had a relationship with Nomura, and where for the first time in January they were informed that in fact Mr Goodfellow contacted Nomura, we would, or the defendants would like an opportunity to go back to Nomura and confirm whether or not this was correct, whether or not there was any contact between Nomura and Mr Goodfellow. And I think they ought to be given an opportunity to be able to verify.
Well, you don't need the permission of the court to get in touch with Nomura and take instructions.
Absolutely not, but the trial is round the corner, and my lord, part of the issue has been that time is moving very fast, and therefore whether or not Nomura respond to any inquiries made by their clients, namely the defendants, we simply don't know. So that's one
Well,
prejudice.
when did you get the witness statement of Mr Goodfellow that we've been looking at?
13th of January of this year.
Well, you've had it since the 13th of January. You've seen what is being said. In a sense, that's when the clock starts ticking. And are you telling me that you've made, notwithstanding the receipt of Mr Goodfellow's witness statement, the second witness statement, that no inquiries have yet been made of Nomura to see whether what is being said can be supported?
Well, my lord, what I do know is that Mr Narain Gupta has responded to this, and maybe I'm making an own goal here, but he's responded to this, saying that this new piece of evidence is quite significant, and he responds to it in his fourth witness statement,
yes,
behind tab 35, volume 5.
Yes.
Page 1296. And there's a section there about paragraph 31 about Tavira contacting Nomura.
Yes. Did you say 31?
Paragraph
yes,
31, page 1296. And so, my lord, we will have to take instructions from Mr. Narain Gupta as to whether or not any inquiries have been made from the Bureau.
Well, but what you're implicitly telling me is that the lawyers have made no inquiries.
The lawyers certainly have not made any inquiries, that's correct.
No. Well, given the state of modern communications, emails, video conferences, FaceTime and so on, I think that the chances are good that you'll have an adequate opportunity to investigate this piece of evidence. If insurmountable difficulties occur, then the court can be alerted. But at the moment, I'm minded to allow this amendment. And at trial, the question of how the case should be justly decided is still an open question. And if there really are insurmountable difficulties that amount to an injustice for this part for this case as refined to proceed, the court can take note of it and then.
I'm grateful for that indication, my Lord. Thank you.
Very well. Well then, so I permit the amendment on the usual terms, which are that the defendant will have any consequential cost of the amendment. Is that it for amendments? Do we move on now?
It is, my Lord. I should just mention, just sort of tidy up on the amendments, as it were. Previously, there was a request made by the defendants to amend their defence in some quite considerable respects. There was correspondence about that, and to a limited extent, we accepted that certain amendments should be made. So there's consent in relation to those. You haven't been taken to them, and I'm not going to take you to them because they're consented to. But what we want is that, obviously, the pleadings are amended, as it were, once only in respect of each pleading. So what I suggest is that we amend our particulars of claim as has been agreed and as you have permitted, and we can do that within a day. The defendant should then be permitted to amend the defence, both as we have consented to the defence being amended, and also consequential upon the amendments which have now been agreed and you have permitted today.
Yes.
And then there's an amendment to the reply, one of which has been agreed between the parties about the appointed representative, and then, of course, there will be amendments consequential upon the amendments to the defence, which is consequential upon the amendments to the particular claim. So I think that it should be, as it were, one set of amendments in respect of each pleading, so that we're not going backwards and forwards and amending things left, right and centre. So that is the way I think it should happen.
Well, give me a proposed timetable for each side.
Yeah, we can do our particulars. Because we obviously know what they all are. I think it's fine, but I don't see why we can't decide it by tomorrow.
And what about your reply?
The defence then would need to be amended. And I would suggest that they be given 1 week to make consequential changes and the changes we have. Yes.
Miss Ahmed is helpfully nodding in agreement with a week for her side to do that. Yes. And then there's.
And then the reply, another week after that, for the one consented to amendment, plus anything consequential from the defence.
Well, can we shorten that a bit? What about 4 days?
Yeah, we can do that. I agree with you. Time is getting a little bit
tight,
so we'll do that in 4 days.
Right.
And what was proposed by the defendants in their skeleton argument is that the parties agreed to bear their own costs of all these amendments. And there's something to be said for that, because obviously you're obviously right about the usual terms on which costs are ordered, but we're both amending. We've both sought the consent of the other side and party being granted. There's been some argument and so on and so forth. My suspicion is that, therefore, it's the simplest thing is actually, rather than trying to salami slice the cost of all these different amendments, that the parties do simply agree to bear their own costs.
Well, I see what Ms. Hartman says.
It was a suggestion made by
your side.
this side, yes, and the skeleton.
Well, all right. So it'll be no order as to these amendments are permitted with no order as to consequential costs.
Brilliant.
Yes, thank you. I think that's just a lot easier for the parties actually to work out.
So does that close the book on amendments now?
That's the end of the pleading point.
Yes.
Excellent.
Next point.
Next, I think certainly on my skeleton arguments, again we're pretty narrowed on this, is video link evidence.
Yes. Well, I've read what you say about video evidence, video link evidence. Is there anything in addition to what you've already said you want to say?
No, the only issue I think you've seen from the present skeleton is whether or not permission should be given in relation to Mr. Goodfellow. And the point about that is you'll see why we say we want permission. The other side says we've got no intention of embroiling him in criminal proceedings in Dubai in relation to the alleged recording of the conversation. Good, we say. What I would ask the court to do about this is grant permission. If it is the case, as I'm perfectly sure it is, that they don't wish to embroil him in criminal proceedings, well, as I understand it, undertakings could be given in that regard by the defendant. My client, Mr. Goodfellow, is extremely keen to come and give live evidence. So if that can be done satisfactorily, he will come and give evidence. But as far as today is concerned, what I ask is that you give permission to him to give evidence by video link, and then we would hope that it simply doesn't need to be exploited because sensible cooperation and arrangements can be made between the parties in that respect.
Very well. Well, I'll hear from Ms. Hartman.
My Lord, I'm not quite clear as to the basis of why permission needs to be granted if the defendants give an undertaking to say that they won't institute criminal complaint against Mr. Goodfellow. And in fact, I've dealt with this in my skeleton argument. There is absolutely no intention for the defendants to do that. And if there is an undertaking that will give some comfort to Mr. Goodfellow, then we'd be prepared to provide that. And so, my Lord, you've seen what I've said about the evidence of video link. It's a very difficult trial in terms of the number of witnesses anyway.
Yeah.
It's going to be made even more difficult by the majority of the claimant's witnesses giving evidence by video link. And Mr. Goodfellow is the key witness for the claimant. And so therefore, my Lord, we say that in circumstances where there are serious allegations being made on both sides, it's incumbent on Mr. Goodfellow to attend.
Right. Well, now, any response, Mr. Greenwood, before I make a decision?
Well, yeah, I mean, only really that, as I understand it from the Dubai lawyers, what we want is a signed settlement agreement in this respect that's going to prevent this thing from being taken to the criminal authorities in Dubai. If that can be done, as I say, Mr. Goodfellow is extremely keen to come. There are two ways of doing it. Either, which is my suggestion, we get our permission today. Alternatively, it sounds a bit, if the other side are keen for Mr. Goodfellow to be there as well, if arrangements can't sensibly be made, then you could just give us permission to revert to you in writing. I don't know whether that's something which sensibly you could deal with in writing between now and the 17th of March, so that it doesn't hang around until the first day of the trial. That may be another practical way of dealing with it. So if the cooperation, as it were, breaks down or is not possible, we can revert without an oral hearing, or maybe a short oral hearing, but that would be a different practical way of dealing with it. As I say, to deal with the possibility of agreement not being possible.
Very well. Well, what I propose to order is this, that for the moment, all of the claimant's witnesses, save for Mr. Goodfellow, for whom permission is sought to give their evidence by video link, the claimant should have such permission. So far as Mr. Goodfellow is concerned, I will adjourn the application in respect of his case for 10 days.
Yeah.
And if the parties can agree on an undertaking that's satisfactory to both sides, well then Mr. Goodfellow will come. He won't. He's not getting any permission at the moment to give his evidence by video link. But I will review the situation if there is no agreement on the basis simply of written submissions.
Yeah.
And I will make a decision on the papers unless I find there really is some very pressing need for a hearing, in which case it would be by video link in any event, because I shan't be in Dubai in 10 days' time.
Yeah.
Right? So that's video link evidence. Good, we're making some progress. What's next?
Yes, excellent. Next is the witness statement of Marco Stadiozzi.
Yes. Now I've read what you say about that.
Yeah.
And so let's hear what Miss Ahmed has to say.
Well, my lord, have you had an opportunity to read my skeleton argument on this point?
Only briefly, because it came to me rather late in the day. Do you want to take me to the...
Yes, indeed. It's section E.
Section E? Yep.
Paragraphs 39 to 41.
Okay. Just sit down for a minute while I look at that. Yeah, I've read that. Well, now, I know something about this sort of trading, and I know something about the regulatory regime, the relevant regulatory regime, both in the UK and here. And having read the proposed witness statement, I didn't find anything in there that was really dealing with anything that I wasn't pretty well aware of. And there's been no permission granted for expert evidence to date. If this evidence has any basis of relevance, it is it's factual and opinion evidence going to a matter which is vouched for by the expertise of the witness. So it's expert evidence. And in my view, it's not needed, and it's just another item in the case which could slow things down, because if permission is given, he's going to give his evidence. There's bound to be, almost certainly, some controversy, given the history of the way this case has gone on between the parties. And time is going to be taken up on matters on which I feel I do not require any acquaintanceship with how these things go. I've got from my own experience in various cases, I've got a pretty good idea of what it's all about.
Yes.
So I'm not minded to permit this evidence. And I feel that if an issue does emerge, both sides are people who operate in this business and this market. And I'm quite sure in the highly unlikely event that I need a little assistance here and there, that I'll be able to get it from other witnesses. So I'm not going to permit this witness statement, with all due respect to the witness, who is completely independent. He's given a very clear account. But I don't need it.
I'm grateful for that indication,
All right.
my lord. In that case, I won't press the point.
Thank you very much. Right. Anything else on witness statements? Where are we now?
Nothing else. Where we are now is the notice to prove the authenticity of documents.
Oh yes. Yeah.
Which is paragraph 30 onwards of my skeleton argument. And my suspicion about this, you will have read what I say about
I have,
that.
yes.
You'll see that it's almost sort of all the documents really that have been disclosed in this case. My suspicion, perhaps looking at what my learned friend said in her skeleton argument about this, is that actually the defendants don't so much complain about whether they are genuine documents as such. What they really wish to say is that those documents are of little probative value and do not demonstrate the dishonesty which has been alleged against the defendants in respect of all those other broker trade. And of course, that I completely understand. It's obviously open to them to say you can't demonstrate that we've been dishonest in those other cases and or it's not relevant and all of that. And I'm not convinced that they, from what they say in their skeletons, that they really do actually wish us to demonstrate the authenticity of each and every one of those documents as a document. Now, if that is what they're saying, then in my submission, first of all, it comes too late, as I've said, and secondly, it appears for the reasons that I have said, and we can go into once you've heard from them, friend, to be simply a blanket request made to some extent without any real consideration of the particular document. And there's no obvious basis for any of the complaints about authenticity. That's what is genuinely being said. And that if that notice is to be allowed to be advanced against my client, then some indication should be given in respect of each of those documents about why it is that the defendants don't accept, if this is the case, the authenticity of those documents, so that my client knows what case it is supposed to be meeting in respect of them. And the court can do that and pursuant to its power to control the way that evidence is adduced to it by parties. So I'm not sure, as I say, ultimately, primarily, I'm not completely convinced that the defendants really mean us to prove the authenticity of those documents as such.
Very well.
That is what they've proved, and I think it's A, too late, B, done slightly thoughtlessly, as it were, and should be controlled by the court.
Well, let me have a short debate with Ms. Ahmed. Now, Ms. Ahmed, we're agreed that authenticity has a very narrow and special meaning here. It means whether the document was genuinely created and is not a fabrication. That's what authenticity means here. It's got nothing to do with the probative value of the contents of the document. Now, bearing that in mind, do I understand that your case here is essentially that these documents potentially have an important role, because perhaps the most important feature of the claim, so far as your clients are concerned, are these serious allegations of conspiracy and fraud, which means dishonesty. Now, you can take it from me that the probative value of these documents is a completely open and live issue. And although allegations of fraud in civil cases are decided in accordance with the civil standard of proof, there's well-known authority that in cases such as this, what is required to discharge the civil standard of proof may well be convincing evidence. It's wrong to characterise it as a case where the proof must be beyond reasonable doubt. That there's high authority from Lord Nichols in a case concerning the standard of proof in child abuse cases. You're probably aware of the decision that the court, since the allegation is so contrary to what one would normally expect, one would expect to find clear and convincing evidence to establish the civil standard of proof. Now, having made that representation to you, do you need to have these claimants prove that these documents were genuine in the sense that they were created and not fabricated, that they were created genuinely and were not fabricated?
I'm grateful for that representation. The objective behind the notice to prove was twofold. The first one was that our clients, in some respects, do question the authenticity of the documents. And the difficulty that our clients have is that they don't have any documentation. For two reasons, and for reasons set out in their document production statements, which I can take you to, and which have been referred to in my skeleton argument at page 18. But essentially the reason is this. Firstly, that there was a burglary at their house, which was quite violent in nature, and therefore that led to a destruction of documents. And secondly, they've searched their computers and their electronic mediums, and they don't have any documents. And therefore, given the timing of the events, they cannot properly conclude whether or not the documents are genuine. And I can see perhaps a point in my learned friend's defence in that there is a slightly wide-ranging approach here because of the reasons provided to us by way of instructions in terms of the documents, and maybe we can go back and reconsider the list and see whether or not our clients can narrow the list of documents that are the subject of the notice to prove. So that was the first objective of it. The second objective was that, again, my clients obviously dispute the contents, and therefore what we didn't want to be criticised for is an accusation that the other side hadn't been put on notice that that was the case.
Well, when you say dispute the contents, what do you mean?
Well, dispute what is said in the emails or in the contents, yes, what is said on the face of the documents.
Well, the probative, I mean, a document contains words.
Yes.
And the court must decide first what the meaning of those words are. If the document is authentic in the sense that it was not dishonestly produced for a collateral purpose, then there are the words, and the question then is, given the court's view as to their meaning, what role do they play in either establishing a particular contention or answering a particular contention?
Yes.
And so I've got a little bit of difficulty in following that last submission that you've made when you say that they dispute the contents of the documents.
Rather the inference arising from what is said in a particular email, for instance.
Yes, I follow. Well, I think that is really covered generally by what I've said to you. You know, of course, the narrow meaning that authenticity has in this particular context. I'm certainly not going to allow I'm not going to make an order that's going to require each and every one of your listed documents to be proved as to their authenticity. That's far too wide, and strictly speaking, it is late. What I would permit you to do, and you must exercise careful professional judgment here, if there are particular documents that your clients have genuine suspicions about as to the creation of these documents. In other words, if they have some well-founded suspicion that the document has been manufactured for collateral purposes, then you could draw up a short list of such documents. And if there's no agreement by the claimants as to the necessity to prove, again, I'll receive written submissions and make a decision.
Grateful to know, thank you.
Did you hear that, Mr. Greenwood?
Yes, that sounds very sensible to me. Obviously, if having considered the matter, the defendants do then refer to, as you say, a short list of documents. It may be that the authenticity of those documents can be dealt with by the various witnesses before the court. It may be that on our side we would need to put in. I'm so sorry, that's it was briefly the fire alarm in Chambers, but it seems to have stopped, so I'll carry on.
Please do.
It may be that we would need to put in some very short responsive evidence in reply to the notice to adduce the evidence of authenticity in respect of those documents.
Well, let's take it in stages. First of all, a small and carefully considered list will be permitted. I will then receive really short and concise written submissions from both sides as to whether I should allow the defendants to dispute the authenticity, notwithstanding that they've narrowed their list. And if I decide that they should, then the court will entertain a request for permission to serve evidence dealing with the question of authenticity.
Yeah, I think that sounds perfectly sensible to me. And it may be that, as I say, that can simply be dealt with by the consultants who's already present.
Yes.
Or produce later
Yes.
documents that satisfies the defendants before we get anywhere near having to make submissions.
Yes. Well, now, I think we'd better put a timetable in place for this. I think this shortened, carefully considered list should be produced. Where are we now? We're on, it's Monday. I think this has got to be produced by close of business on Friday, this coming Friday.
Yeah.
Your response to that list must be by close of business the following Tuesday. And that response should be served on the court as well as on the claimant. And the claimant will have to close of business the next Friday to respond in submissions. And again, of course, the submission should be served on myself. But, and that service on the court will be service to the registry, who can then cut me into a loop. Now, I hope very much that this is not going to lead to the court having to make some final determination on the matter. I want you both to exercise sensible professional restraint and common sense on this question. So that, for instance, if in fact, whatever the very, very strict legal position might be, the authenticity question can be fairly easily dealt with by witnesses already due to give evidence. But then let's just do it that way without having an argument put to the court. Yeah. So I think that deals with that, documents to prove.
Thank you very much.
And now we move to?
And now just going through my skeleton, there's the question of the interpreter required for the fourth defendant, and I think there's common ground that she does need an
Yes,
interpreter, so
yes.
that should be very simple to deal with.
Certainly, the registry must make the necessary arrangements.
Yes. I don't know whether friends wish to say anything about that.
My Lord, we propose in our skeleton argument that the parties can hopefully cooperate and agree directions in terms of an interpreter and for the registrar to be able to provide a suitable interpreter. I don't think we need to take up the court's time with that issue unless Mr. Greenwood has anything to say.
No, well, I think what's contemplated is that an interpreter must have the benefit of an interpreter. A request should be made of the registry to propose an interpreter, and then if the parties have any difficulty with that, they're going to have to propose their own and demonstrate why that proposal is superior to any suggestion that comes from the registry. All right?
Grateful indeed. Thank you.
Okay. Now, is that your lot, Mr. Greenwood?
Only the very last thing is, and I think again, my little friends, I think we can deal with it together. It's just a timetable. We proposed in very broad terms a timetable for trial, and what we essentially proposed was that it's 5 days at the moment. The first half a day should be brief openings and or any housekeeping applications that might have arisen before then. We should build in that possibility. What we would then say is that Mr. Goodfellow should begin to give his evidence at 2 o'clock or after lunch on the first day. And the only other thing that we said then about evidence was that we thought that the parties should have an equal amount of time for cross-examination of the witnesses. I appreciate I have more witnesses, but on the other hand, we have the same territory to cover. So obviously, I have to cover with the defendants, witnesses. I have to cover all of the territory in respect of the other similar fact allegations, and they have to cover those matters with my separate witnesses. So I would say that it would be fair to allow for a sort of equal division of time. I can't say more yet about the order of my witnesses without knowing a little bit more from a learned friend about how long she would be with each of them, because obviously they're in different jurisdictions and there's going to be a question of working out video links and stuff. And so that's something I think we need to discuss. My learned friend has suggested that we should essentially cooperate, talk to one another in the next 7 days and try and sort out the timetable. Ultimately, I think that's the best way of doing it rather than troubling you with this discussion. The only other thing I would say about it is that after hearing all of those witnesses, I think that it would be very difficult, and there probably wouldn't be time anyway, to close properly in Dubai, as it were, on the 22nd of March. What I would suggest is written closing submissions, and then at trial you can consider whether or not you would wish for some further oral closing. But again, I don't think you need really to think about that today. I would suggest that's a matter of management which you can conduct sensibly at the trial itself.
Well, I'm going to tell you now that the court hours will be beginning at 9:30 and concluding at 5 in the afternoon. There'll be an hour's adjournment from 1 till 2, and there'll be a short break in the morning and a short break in the afternoon.
Yeah.
Now, a timetable must be established. I shall leave it to the parties in the first instance to agree a timetable. But if there's no agreement, I will impose a timetable, and it will be a timetable that I will require to be strictly adhered to.
Yeah.
Now, as to closings, this gives rise to a further matter that I want to come to. It would assist the court if there was something the equivalent of live milk provided in the course of this trial. with the two of you, both sides sharing the cost. Where submissions are going to be served after the court has conducted the hearing, a transcript is absolutely essential. It's probably also extremely useful, even if the submissions are made when the court has got a fairly fresh recollection of some of what was said. So I urge the parties to agree to a live note transcript, which will allow the court to have a transcript overnight, an hour or so after the court has risen, and also to have an authentic and complete record of how the evidence has gone. This is very much an evidence-driven case. And I would like you, both sides, to confer on that request from the court and to let the registry know in 7 days what your response to that request is.
I can say that we do think there should be live notes, so I can confirm that we're more than happy to comply with that request, something that I would very much have wanted.
Right, well, in the optimistic anticipation that this will be agreed, I would imagine that I would hear some very short oral submissions where particular headline points can be made, that thereafter we'll set a timetable for the service of written submissions. And the judgment will be reserved, and the judge will have the great benefit of a full verbatim transcript of the cross-examinations. I'm only going to give you about an hour each to open. I'm capable of reading, and I shall have your written opening submissions, and I will have mastered those before the trial begins.
Yes, I was not even, as I say, it was really just in the interest of caution. It may not even be that one requires that, but it's probably no bad thing to anticipate that possibility.
Miss Ahmed, are there any other matters that you wish to raise?
My Lord, there are two matters that I would like to raise.
Yes.
If I can invite you to turn up my skeleton argument, please.
Yeah.
I don't know to what extent you were able to read the sort of factual summary that I provided in relation to the case, starting at paragraph 16.
Well, I did read it. Again, at a bit of a gallop.
I'm grateful for that. In which case, then, the two matters that arise out of those facts that the defendants would wish to raise are the choice of law. That's the first matter, and the second.
Oh, this is on the question of the special damages.
It is, my lord.
Well, I can't. I'm sorry to cut you off.
No.
I can't make a decision here, and it's not appropriate for this to be a preliminary point when the trial is so close. This is going to have to be something that's going to be argued and determined at trial. So it's going to be an issue to be dealt with. And so each side must come prepared to argue the applicability or the non-applicability of the special damages provision.
My Lord, I hear you. May I make a few observations, please, with your indulgence, of course? The reason why the defendants would like this matter to be dealt with before trial, and even if it's by way of submissions or by video link, is this. Firstly, in terms of the Article 42 point, we say that the threshold is very different to, let's say, an exemplary damages claim. We say that the burden of proof is very different, and we say that the evidence that needs to be led is very different. And in terms of dealing with both an exemplary damages claim as well as an Article 42 claim, will put the parties, and particularly the defendants, at considerable cost, and therefore we say in order to avoid that cost, where costs are spiralling, I mean the costs of going to trial for the claimant are more or less the claimed amount, we say that in order to meet the case, in order to keep down costs and for the issue of proportionality, that we'd invite the court to perhaps hear this as a preliminary issue before, in fact, going into trial.
It's just not feasible, I'm afraid, given the resources of the court, in particular my own availability. And so far as the cost is concerned, your interest is to ensure that the special damages provision, I call it that, is not applicable, because on the true analysis as to the governing law on the issue, it doesn't come in. It's all English law.
Yes.
And in English law, there are, of course, authorities as to punitive damages and the like, but that's completely different. And I forget whether that common law approach is pleaded or not. What is pleaded? We know
it is pleaded, my lord.
It is. Okay, it's pleaded. Fair enough.
Yes.
But you have a particular concern, which I can understand, about the special damages provision in the DIFC legislation.
Yes.
Now, what I'm afraid you have to do is that you have to proceed on the basis that that may be the applicable provision. At the moment, I don't see how that approach is going to be particularly costly to you. I mean, can you give me some idea of costs that would be avoided if you received a judgment on a preliminary issue in your favour?
Yes, my lord. So, for instance, in terms of the written submissions, we would have to deal with both Article 42 as well as exemplary damages that are being claimed. Yeah. And as I've already said, the Article 42 claim is completely different from exemplary damages. And the case of Karafi,
I know that
Deputy
very well.
and we do as well on this side of the table, having had conduct of it.
Yeah.
But if I can just read a paragraph from Deputy Chief Justice Chadwick's judgment on this point.
Yes.
I have the authority in front of me. I can hand up another...
No, it's all right. Just read it. Read it out.
If I can find it. Sorry, I beg your pardon. I'm just trying to find the correct reference.
Take your time.
Paragraph 168 at the bottom, so I can't find it. So paragraph 168, the last part of that paragraph, refers to the issue as to whether or not the defendant, Saracen Alpin in the Karafi case, could obtain assistance from the principals of awarding exemplary damages in the UK.
Yes.
And what Deputy Chief Justice Chadwick said on that point is, nor do I think that Saracen Alpin obtains assistance from the principles which could guide a court in England and Wales when deciding whether or not to award exemplary damages. Article 40, subsection 2 is not derived from the law of England and Wales. Rather, it reflects an intention to depart from that law in favour of the law in the United States of America. The lawmaking authority in this jurisdiction has given the DIFC courts power to award multiple damages in appropriate cases, and the court should not decline to exercise that power. So what we say, my lord, is that these are two different, very different heads of claim, requiring very different submissions, requiring a very different burden of proof, and therefore the costs that will arise dealing with these two different points are those in terms of written submissions, in relation to cross-examination, the time that will be taken to deal with these points, in terms of closing submissions. Well,
I'm not readily persuaded by this submission, because the facts are the facts, and because of the fraud allegation, there's going to be, in any event, a very considerable investigation into the conduct of both sides, and in particular the defendants, whatever the whether it's common law damages or whether it's the special damages provided for within the DIFC. True, you're going to have to consider particular submissions addressing the DIFC provision, but I don't see that as amounting to really significant costs against the context of the overall costs of this highly contentious dispute. So I've heard your submission. You've made it very attractively, but I'm not going to order a preliminary issue on this question. I don't think there is a sufficient saving of costs, and having regard to the resources of the court, and in any event, the amount of evidence which will be relevant, which inevitably is going to be explored because of the fraud and conspiracy allegation, that it is that you've made out a case, the burden of which on you is quite a high one, for a preliminary issue.
Well, my Lord, there is one final point,
yes,
and that is the prejudice that would be caused to the defendants in not knowing the case that they have to meet with regards to the law that's applicable to these issues, and therefore on that basis, and I hear what you say about the resources.
well, it's going to be that's going to be in the skeleton arguments. Have we? Is that something that's in the agreed timetable when the skeleton arguments are going to be produced before trial? Yeah. What's the time set?
I think it's 3 days before.
3 days before.
I think.
It's the 11th of March, I think it worked out at.
And remind me of the start date.
The start date is Sunday the 17th. And I think that the Monday, the 11th of March is the Monday, the week before, and that's 3 clear business days, and that's what the timetable says. So it's the 11th of March, so in effect, 6 days before the trial will start.
Sorry, I beg your pardon.
That's all
so
right.
I can take
Quite
instructions,
right.
yes.
Well, of course you will be assisted by seeing how the claimant puts its case as to why this provision of DIFC law should be applicable in circumstances where the governing law of the alleged contract is English law. And to some extent, the ground has been traversed, and I've read certain submissions being made as to why the Dubai provision, the DIFC provision, should be applicable. So I don't think you're going to be taken wildly by surprise when you finally get the skeleton argument. And in any event, you're going to get it on the 11th, which is some days before we get to trial. And as I said, factually, the whole thing's going to be dealt with in any event. So I don't think there is any necessity or justification for me ordering, in advance of the timetable already set for written submissions, for some earlier set of submissions dealing with this particular point.
My Lord, on the basis that it is sequential exchange of skeleton arguments...
Is that what's been agreed?
I'm just checking. If not, you can check that. What I would propose, and we're subject to checking whether or not it is sequential or simultaneous exchange, is that we do have sequential, because at the moment, on this side of the room, the defendants are unclear and uncertain as to what and how the claimant is putting its case in relation to the applicability of Article 42 and DIFC law. And we've tried to cover this in correspondence, and the only explanation we've had, as I've said in my witness skeleton argument at page 11, is that, well, Karafi applies, but we say Karafi doesn't apply, because Karafi can be distinguished. So, therefore, if it hasn't already been ordered, then we would propose and invite the court to make a direction for sequential exchange, given this point, so that we can respond accordingly. And therefore, that cuts out any prejudice to the defendants.
Well, Mr. Greenwood, what do you say?
What I said, I think currently it is not ordered that they be sequential. Currently, it's ordered that they be exchanged. And this particular small aspect certainly does not warrant making any change to that. The parties essentially know that we would say, part of the law of the forum and law, that the particular DIFC law says it simply applies in any case over which the DIFC courts have jurisdiction. And Mayank has been able to produce a skeleton argument saying, no, it's a matter of substantive law, therefore English. So we know essentially the shape of the argument. And there's nothing in that circumstance to justify changing the order that has been made for an exchange of arguments, which will be essentially about everything else in the case. As you say, all of these issues will have to be dealt with anyway.
Sorry to interrupt you. There is currently an order for mutual exchange. Is that correct?
There is.
And that was made by a judicial officer of the court.
Yes. Yes, it was. At CMC.
Yes,
Made on the 23rd of October 2018.
All right.
By Mayank.
Yeah. It's all right. I don't need to see it.
No.
Well, the case had been fully pleaded out by the time that order was made, and I'm not persuaded, I'm afraid, Miss Arnett, that we should depart from that order and order in its place sequential exchange of skeleton arguments. I think you've got a pretty good idea of where the battle lines are drawn on this point. Any other matters?
Yes, my lord. There is a request for additional documents.
Yes.
It's covered in my skeleton argument.
Yes.
Paragraphs 33 onwards, page 14.
33. Yeah.
Now, my lord, this is a request for documents that has been made right at the start of the production phases of the proceedings.
Yes.
And, my lord, it seems to be the most controversial area in this case because there's significant kickback from the claimant in terms of any requests for documents that are being made. And what the claimant seems to say, well, look, they're not relevant to material, and what we say that they clearly are. And my lord, the three areas or categories of documents that we seek are as follows. The first one is in relation to the status of Mr. Andrew Horgood. Now, you may recall that Mr. Horgood was the trader at Tavira who executed the trade.
Yeah.
That's the first class of documents. The second class of documents that we seek are in relation to the claimant's regulatory obligations, and obviously you will have seen our defence whereby we say that there was a representation and implied term of any alleged contract that the claimant would comply with its regulatory obligations.
Yep.
The third class of documents that we see is in relation to the settlement of the trade, and you will note that one of the parts of the defence of the defendant is that the claimant didn't execute the trade in the best interests of the defendant, and in fact didn't provide documents or verification of any trade that had taken place, or any settlement. Yes. So it's those sort of classes of documents that we see. Now, in terms of the first category of documents, the status of Mr. Horgood, and this is relevant to the amended pleading as well. You've already seen the pleading. If I can quickly take you to that, it's behind tab 4, volume 1, and this is the amended pleading now.
We have agreed to give 38.1a and b, and I know time is very short. I think you've only got another 10 minutes.
You've agreed 31A and B, all right?
Yes, of course. Yes, we had the call.
Yes. Well,
Thank you for that. The second one is in relation to the claimant's statutory and regulatory obligations. Before I proceed, maybe I can be reminded by Mr. Greenwood as to what the position is in respect of those requests for documents.
Can you help there, Mr. Greenwood?
So I didn't really catch that.
Well, I'll get Ms Ahmed to repeat it. It's to do, I think, with the regulatory aspect of
Yes,
the case.
of course.
Do you want to...
What, oh, sorry, Mr Greenwood, before I proceed with my submissions, perhaps an indication from you as to the position of the claimant in relation to our request at 38.2 of the skeleton argument.
Well, 38.1, as I say, A and B, we're willing to make a search for that, not little c. 38.2, as I think we have made clear, we don't agree to give anything at 38.2 or 38.3. And the reason for that, my lord, I don't know, it was probably very late last night or early this morning. You were sent, I think, a little note asking whether, if possible, you could read our quite long response in correspondence.
No, I didn't get that. I didn't get that.
Oh, no, not to worry too much. Our response is you may wish to have it, maybe convenient, it's at file 6.
My lord, before
Wait a minute. Hang on, Mr Greenwood, sorry.
Before Mr Greenwood gives his response, may I just outline the reasons why we're requesting the documents, and then perhaps Mr Greenwood
Yes,
can
I think
respond.
that's fair enough.
But given
Yeah,
the-
we'll hear Ms Ahmed, then of course, Mr Greenwood, I'll hear you. Yes, carry on, Ms Ahmed.
Grateful, thank you. My lord, if I can ask you to turn up the defence, it's volume 1.
Yes.
Rather, I beg your pardon, if I can deal with 38.1c, as I understand
Yes.
of my skeleton, as I understand that the claimant isn't willing to disclose the disclosures made to HMRC in respect of Mr Walgood. Perhaps if I can start with that.
Yes, so
first.
that's 38.1c you're on.
Yes, indeed.
Okay, which file do I need?
Now, if I can perhaps just outline the premise of our request. Firstly, there's a complete question mark over the status of Mr Walgood. And rather than taking you to the document, you will have noted that in the first particulars of claim, it was suggested that Mr Walgood was an employee. The claimant is now seeking to amend that by saying he's not an employee.
Yes.
As far as we're concerned, the defendant's concerned, there is a black hole as to what his status was. And that goes directly to the issue as to whether or not Tavira was authorised to settle this trade with the defendant. Now, the defendant rather has tried to get to the bottom of this issue consistently and constantly. And the first time that it attempted to do that was by way of its request for further information. And if I can ask you to turn up that's at F2, tab 11, page 311.
Yes.
At page 312,
Yes.
we tried to bottom out the basis upon which Mr Andrew Morgan was providing services.
Yes.
However, the response that we got is behind tab 12,
Yes.
and there was a lot of, it's embarrassing, he's not an employee of Tavira, but again, it didn't go towards why and on what basis he was actually providing services, arranging the deal, or executing the trade on behalf of the claimant. And so that was the response that we got there. The second time that we tried to bottom this out was in our request to produce. And my lord, I don't know if you have a copy of the request to produce. It's behind F6, tab 37A.
37A.
Yes.
Yes. Yes, I've got it.
Page 1334A.
Yes.
Because in the reply, the claimant's
Well,
reply...
just show me where the request is first. I mean, I've got the document. Where do I look?
Yes,
Which
page
paragraph?
1334D.
D.
And it's request number 2,
Yes.
wherein we wanted documents evidencing the alleged relationship of agency between the claimant and Mr Andrew Horgood. And that was on the basis that the claimant had said in its reply that Mr Horgood was an agent.
Yes.
This was met by an drawn-out, technical and formulaic response, which amounted to an objection, which simply said, no, we're not giving you the document. When it came to the court passing an order, there was no document production order for those documents in relation to Mr. Horgood.
That was the junior judicial officer.
Yes, it was. Yes, it was.
Did you make any challenge to that?
We were asked to provide clarifications. We did provide our clarifications.
Okay.
Again, no production order was given, and no, we didn't make a challenge to that, my lord. I'm afraid.
Late in the day, isn't it?
Well, my lord, we say it's not, because the background gets even murkier with Mr. Goodfellow's witness statement, and I think you've already seen his witness statement. It's behind tab 4. Volume 4, tab 26, page 79. It starts at 796, and it deals with Mr. Horgood.
Sorry, just wait for a minute. I've got so many files here. Yes, I've got 4 now. Give me the tab.
It's tab 26.
26,
And
yes.
it's paragraphs 17 and 18.
17 and 18.
And if you could perhaps just read those
I will.
paragraphs.
I will. Yeah.
And therefore, on the basis of those paragraphs, it's even more difficult to determine what his status was. Now, going back to your observation, my lord, about being late in the day, we say not necessarily given the chronology in which these events have transpired and the procedural timetable. So production, standard production, actually was completed, or the stage of standard production was completed on the last day of last year. So that was the 31st of December. We then received this witness statement of Mr. Goodfellow's on the 13th of January, and we're right to make a request for these additional documents later in January. We are then dealing with the progression of the case, and my lord, it raises its head on the basis of the amendment that the claimants are now seeking to make. And so, my lord, we say that this request has always been there. It's not been late given the timetable, the nature of the timetable, and therefore we say that it's a crucial issue in the case as to what Mr. Horgood's status is, particularly because Mr. Horgood isn't coming to give evidence.
But if Mr. Horgood, as a matter of fact, set this deal up for the claimant.
Yes.
And the claimant, if you like, took the fruits of Mr. Horgood's activities, which ended up with being presented with the opportunity for this trade, if I can put it that way. Mr. Horgood is the agent for this particular transaction, isn't he?
My lord, it goes further than that, and that is whether or not there was any authority for him to enter into this alleged contract for the trade. Because, my lord, part of the defendant's defence is, and perhaps if I can take you
to... It's all right, go on, you don't have to take me anywhere, just
part of the defendant's defence is that there's a general prohibition in relation to placing or doing or conducting transactions with where there is no authority to do so, and it's Section 19 of the Financial Services and Markets Act. And, my lord, the defendants are relying on that general prohibition to say that Mr. Horgood and Tavira Monaco had no authority to enter into this trade transaction with the claimants. Now, the effect of that is that it renders the alleged contract
But it's a very funny state of affairs, isn't it? That here is a man who is, in the course of his dealings with your client, in effect negotiates and persuades them to place a trade with the claimant. It's rather surprising that he's not their agent for that purpose. And you don't have to have, in the commercial world, you don't have to have powers of attorney duly authorised and witness and everything else. If, as a matter of fact and common sense, this man was acting on behalf of the claimants, he was acting on behalf of the claimants. The regulations don't require that the authority consist of some particular piece of writing or anything else, do they?
Well, my lord, in my submission, they do.
Well, show me where in the English regulations there is a requirement that the authority of an agent is actually vouched for in some written agreement.
Well, my lord, I don't have that here.
You can't. I don't believe there is such an arrangement, a provision.
Well, my lord, there's certainly a provision that in order to conduct trades of this nature and transactions of this nature, that there has to be regulatory authority or authority by the regulator of a particular person or an entity conducting that transaction.
Yes.
And the simple point is that we say that there was no regulatory authority to either Tavira Monaco or to Mr. Hawgood in terms of conducting.
So what you want documents to evidence that he was authorised in the eyes of the regulator. That's what you're really putting forward.
Yes.
Is that right?
Yes, my lord, and the basis upon which that authority arose. Because what Mr. Goodfellow is saying is that, well, he was sometimes sitting in Tavira, London, he was sometimes sitting in Monaco, he had a desk space, but he wasn't working exclusively for us. I mean, at the moment, it's just not clear as to the authority on which he was transacting.
Well, you better show me the provision. Having asked you not to, I now think it's probably best that you show me the provision in the UK regulations that require that an individual doing business on behalf of a financial institution is authorised by the regulator to carry out that function. Where do I see that?
Well, my lord, if I can just perhaps take it in stages. So, firstly, we say that Mr. Hawgood was carrying out a controlled function because he was dealing with customers. And I don't have the FCA handbook with me, but there's various levels of control functions, and we say he was carrying out one of those. If he was carrying out a control function, then he ought to have been registered with the FCA and been on a register. There is no evidence or documents that he was in fact on any register. So that's the second point. The third point is, my lord, then, in terms of arranging deals in investments, therefore, there is, I mean, it's part of the Financial Services Markets Act, that a person has to be authorised in order to arrange deals or carry out transactions.
Now, authorised by the regulator or authorised by the principal?
Authorised by the regulator.
All right, so you want any documents that are relevant to the authorisation by the regulator of Mr. Hawthorne, right?
Indeed, yes.
Now that seems to me to be the key to it.
Yes,
because of your regulatory defence.
Yes, that's the first part of it. And the second part of it is this, that given the shifting case as to whether or not he was an employee or whether he was an agent, the second part of the request would be those documents, or if there are any, or a search for documents, to substantiate this idea that's being proposed, that Mr. Hawgood was acting as an agent in the ordinary sense.
Yes.
So any contractual documentation of the agency relationship between the claimant and, between Mr. Walgood and the claimant.
Yes. So it's those these are the two categories that we find it down to.
Well, my lord, the defendants have agreed to the first category,
yes.
Paragraph 15. So A and B, they've already agreed to that, or
yes.
conducting a search for those documents.
Yeah.
So that's paragraph 15 of my skeleton.
Yeah, wait a minute. Let me go back to your skeleton.
And it's the literacy that the claimants object to.
It's C, yeah.
Yes, and the reason why we make that request is because Mr. Goodfellow, in his witness statement, states that Mr. Hallgood was also operating out of London, but there was no formal contract, or certainly there was no formal employment relationship.
Yeah.
So, my lord, it's a question of substantiating that point and providing evidence as to what his tax status was then.
Oh, come on. You're not getting any documents as to tax status.
Well, the disclosures that were made here
No,
to
you're not getting that. I'm not going to order that for one moment. It's very widely drafted. You're not going to be given access into his dealings with the Inland Revenue authorities. This matter can be dealt with in a much more focused categorisation of the relevant documents. At the moment, I'm subject to hearing more from Mr. Greenwood. I would be disposed to require the claimants to conduct a search, and if anything is found, to produce documents relevant to regulatory authority stroke approval for Mr. Hallgood to do this sort of business on behalf of the claimants. And secondly, although I think this may already be wrapped up with what's agreed, documents as to the basis upon which he was carrying out these functions on behalf of the claimant, whether he was how he was treated. Was he an employee? Was he an agent? Or was there a relatively informal arrangement whereby, without specific formal documentation, he nonetheless had a defined function to act on behalf of the claimant? Now, am I right in thinking that as to that last category, that's been agreed now in A and B?
Yes.
So the contentious one is your request for the revenue documents. I'm not going to allow that. That's far too unfocused a request for documentation. You'll have this. You'll have the. You've got Mr. Goodfellow's evidence as to how he was treated, and you're going to be subject to what I hear from Mr. Greenwood. At the moment, I'm minded to order a search of documentation relating to the authorisation by the, if you like, regulatory authorisation of Mr. Hallgood. And I regard that as far as you're entitled. So now, Mr. Greenwood,
yeah.
You've heard.
Yes, well, as I say,
you've heard the debate.
Thank you very much for that.
So what I'm asking you now is, what's your response to what I'm at the moment minded to order, and that is that you search for, and if you find, you disclose documents that relate to any authorisation by the regulatory authorities of Mr. Hallgood to produce to produce business for the claimant?
Well, first of all, the point about the only thing that we're actually asked for, and there's no application, of course, no written application about any of this, is identifying skeletons, the things at 38.1, and we've agreed to give 38.1A and D, and that relates to the particular factual basis upon which Mr. Horgood was seeking and providing services.
Yes.
We will do that.
Yes.
In relation to the other aspect, which Madam Professor has raised already this morning, it's not pleaded that Mr. Horgood was conducting a controlled function, and it's not actually pleaded that he required any sort of specific personal authority from the FCA, and we would deny that he did require any sort of authority from the FCA. It's not a pleaded issue. And so I would resist that category, because, as I say, it's only been raised already today. It's raised in relation to an issue which is not pleaded. And so, although I hear and obviously understand what your lordship is saying about that, in my submission, that's not an order that should be made now. It doesn't actually arrive at that it isn't pleaded currently by the defendant.
Well, it strikes me at the moment as having a connection to the overall defence as to the implied term that this will all be in accordance with the applicable regulatory regime, which it is argued it is not. And it's been explained to me that there would be a breach of the regulatory regime if Mr. Horwood was not properly authorised, sanctioned, or whatever you however you term it, given the function that he was performing. And at the moment, although I take your point that it may not be pleaded, but I can see how that has a bearing on the defence. I don't see it as a particularly burdensome requirement on you. There would have to be a search as to whatever the situation is. And, of course, it's open to you to contend that none of this was necessary in any event.
Yeah. Can I say one thing, then, in that regard? Rather than, as it were, any documents that might relate to authorisation, could the search be limited to documents containing any authorisation that was necessary, sought and given?
Well, let's see what was
then there may be none, and let's say, you needed authorisation, and we're going to say something about that at trial. Or there may be something, in which case the opposite may obtain. But if it's simply documents that relate to authorisation, I can see then that at this late stage of the day that might entail.
No, well, that is quite broad. I can see that. Let me just ask Mr. Ardner, what is crucial for this part of the submission that you've made to me is whether he was authorised or not. And so it seems to me to be reasonable to refine your request to a request for documents that contain an authorisation from the regulator to perform this particular function. If it was obtained, it was obtained, and if it wasn't, you have your argument, well, then it ought to have been. And so this is one aspect of the breach of the regulatory regime.
My Lord, I'd just like to take a moment to reflect on what Mr. Greenwood is saying and perhaps deal with it maybe after the hearing. But at the moment, as your learned professor so eloquently formulated the request, that is probably more in line in terms of the documents that we're seeking rather than the narrower request. My concern is this with the narrowing of the request, that the defendants have made, the claimants have made a point that, in fact, Tavira Monaco was authorised, to put it loosely, and therefore Mr Hawgood's authority is neither here nor there. And we say that that's not quite the point that we're making, and therefore, in terms of narrowing this request, I just wonder whether or not it sort of obviates what we're trying to get to, the point that we're trying to get to, and that is Mr Hawgood's authority.
Well, I'm going to say something about that.
Yes.
The application made in relation to the authority document containing or relating to the authority of Mr Hawgood isn't made in the letter of skeleton argument. It's been raised orally today.
Yes.
And that's fine. I've dealt with it. But the idea that she should now go away with the defence and think about it further seems to me to be impractical, really. You've heard argument about it. It's been raised today. I've dealt with it as best I can. In my submission, there's a premium, really, on some clarity and certainty. And you should make the order today, which I can hear you're minded to make, but make it in terms that are reasonably likely to be able to be complied with sensibly by my client in the time that remains, and we'll do that.
My Lord, this request doesn't come out of the blue. This request has been made since the start of January, if I recall correctly, in correspondence. And so my learned friend has been on notice, and certainly his solicitors have been on notice, that we have been seeking documents in relation to the regulatory status, if you like, of Mr Hawgood.
Well, I'm minded to make the order in the terms that I've outlined to you, and that is that there must be a search for and production, if they are found, of documents containing regulatory authorisation of Mr Hawgood to carry out the function which it said he was carrying out. Now, I'm going to make that. I'm not satisfied that any wider disclosure ought to be made. You may well have raised this earlier in January, but it isn't pleaded, and I'm not taking that point against you in making this order. I think we've got to settle this here and now in the PTR, and that's the order that I'm prepared to make. I'm not persuaded to make any wider order on the question of regulatory authority.
My Lord, if I can make another observation, whilst it might not be pleaded now, my Lord, but the claimants have put in an amendment in relation to Mr Hawgood's employment status, and therefore we have an opportunity to respond to that and plead to that. And we would plead to that in terms that Mr Hawgood was carrying out a control function without regulatory authority to do so. And therefore the question arises again.
Well, I'm giving you a specific disclosure order in respect of whether he was authorised. That's what I'm ordering.
I'm grateful. My Lord, my second category of request is set out at 38.2 of the skeleton argument.
Yeah.
And my Lord, this relates to the claimant's statutory and regulatory obligations. And my Lord, the overall defence, as you put it, is that whether or not there's a question mark as to whether or not the claimant adhered to its regulatory or the regulatory regime it was operating in. My Lord, in terms of the defence, if I can perhaps set out what it is that the defendants are saying in terms of their failure, claimant's failure to comply with the regulatory regime. If I can invite you to turn to Volume 1, Paragraph 5. Sorry, Tab 5. Volume 1, Tab 5. That's the defendant's defence.
Yes.
And at Paragraph 16.4, it refers to the claimant's failure to take any reasonable steps in terms of countering financial risk in terms of anti-money laundering.
Yes.
So that's part of the failure that the defendant alleges. In respect of the other failures, the defence talks about regulatory requirements and the fact that the claimant didn't comply with those. Those were set out in more precision and in detail in the defendant's response to RFIs that the claimant have served. And if I can invite you to turn to that, it's volume 2, tab 10.
Yeah. Yes.
And page 303, in response to a request, and it's
Page 303?
Yes.
Oh yes, I see, down the bottom there.
Yes, defendant's
Yeah.
response to request 5.
Yes.
That sets out in more precision the failures that the claimant
Yes.
relies on.
Yes.
And as you can see, it talks about compliance with financial crime, money laundering.
Yeah.
And then further on into this document, page 305,
Yes.
it talks about failures in respect to the COBS part of the FCA handbook.
Yes.
Again, money laundering. And then page 306 talks about failures in respect to providing contractual account opening documentation, completing anti-money laundering. And then page 307 talks about COBS 2.2.2 and failures therein.
Yeah.
This is then further set out in the second defendant's witness statement, page 30, tab 35, volume 5. I beg your pardon, volume 5, tab 31.
Yes. Yes. Which paragraph?
Paragraph 43, and in particular 43.2, ABCD, page 1095. Mr. Gupta.
1095, yes.
Yeah, 1094, 1095. Mr. Gupta provides details as to the basis upon which he alleges that there was a failure of the regulatory obligations of the claimant, and he refers to A, COBS 3, which deals with client classification, 3.3.1, again, client categorisation, notification of that categorisation to the defendant.
Yes, all right.
And so, my Lord, it's a central point of this case, the failures of the regulatory regime. And in accordance with the FCA handbook, the claimant was required to maintain systems, policies and procedures that would demonstrate that there was compliance with the obligations that we say the claimant referred to adhere to. And therefore the request that we're making is in relation to policies and procedures, and I go back to 38.2, those policies and procedures that the claimant had at the applicable time in respect of account opening, client categorisation, and in respect of money laundering or countering financial.
Well, have you asked for this previously?
Yes, we have.
And it was refused by the judicial officer?
Yes.
And you didn't appeal that?
Well,
I mean, there has to be some sort of sense of good business practice here, you know.
my Lord,
I mean, the reason we have this setup where the question of the disclosure and production of documents is regulated by requiring written requests to be made and justifications advanced for the request, and then the judicial officer makes his determination. And as you know, there's a de novo appeal to a judge of the Court of First Instance from these decisions. I've dealt with more than one appeal from the judicial officer, and you haven't taken that step. And here we are now with the trial coming up in mid-March, and now you want this.
Well,
what's your explanation for that?
My explanation is this, my Lord. As I've already said, the timetable has been quite shortened and it's been squeezed. And so the defendants were asked for clarification in respect of their requests. That clarification was provided, and from memory, the judicial officer made an order, I think mid-November, late November. Then, my Lord, we got into the realms of putting together witness statements and filing witness statements, and my Lord, that
This
rather...
is no excuse whatsoever. There's a time in which you can apply for a de novo hearing, and it's a de novo hearing. Everything is up for grabs, and you haven't taken that step.
Well, my Lord, if I can perhaps give you an explanation in terms of the defendant's approach to all of this. Every time a request has been made or an application has been proposed, there's been an accusation of derailing the timetable or derailing the trial. And my Lord, in terms of the defendants and their attitude to all of this, is they do want to get to trial and they want to be able to deal with this without being accused of trying to derail. And therefore, my Lord, there is a certain reluctancy of trying to persuade the other side to deal with these in a satisfactory manner. And my Lord, we would say that there hasn't been a significant passage of time, given that, as I've said, production was closed, or the stage of production was closed in December, and we are in mid-February, my Lord.
Well, I'm afraid that's a speech of mitigation rather than a proper plea of not guilty. Now, let's just go back to what you're after again. In respect of this, it's 38.2 in your skeleton.
Yes.
Let me just have another look. So you want, it's A, B, C and D in 38.2. Mr. Greenwood, what do you say?
Yeah. Well, we've written at length in correspondence about this at the end of January. There are many, many reasons for you not to make this order, not least of which the one that you've just been discussing with my friend. Fundamentally, these documents are not relevant to the case as it is currently pleaded. What is currently said is that there are breaches of various regulations, and that was pleaded back in 2018. What is now asked for is a very broad, open textured order in relation to internal policies and procedures applicable at the time. Now, whether or not my client was in breach of its own policies, it doesn't seem to me to matter one way or the other. Of course, no allegation can be made in respect of any of that, because defendants have never seen any of that stuff. So it's not pleaded, can't be pleaded. In any event, it would be hopeless, as I say, because it relates only to what internally my client might have said as a matter of its own policy. This application is made very late. It's not made in writing. It's been an order already. And as I say, fundamentally, it's irrelevant. If these documents were now to be searched for, it would take time. There would be a lot of them, I suspect. And then goodness knows what that would lead to in terms of any possible amendments to the pleadings, because the way that they asked for those documents in January was in conjunction with a draft amended defence, which raised, or attempted to raise, a case based on breach by my client of its internal policies. And we said, no, it's all too late to do that, and it is irrelevant per se, and it would be hopeless. And that proposed new case was then abandoned by the defendant. And in abandoning that, they have implicitly abandoned any possibility of seeking, even in principle, these policies and procedures. So, as I say, as we set out at length in correspondence, there are multiple reasons why this order shouldn't be made, whether now or even previously.
Could I ask you this, Ms. Ahmed?
Yes.
There are, of course, certain requirements under the regulatory regime which, if not complied with, can render unenforceable a financial services transaction. Now, is it the case that if a regulated provider of financial services doesn't have a compliant policy and set of procedures, that will work its way through to any business that it does and render it unenforceable.
My Lord, to answer to your question, no. However, what we say is because of the case the defendant is bringing, that there was an implied term that the claimant would comply with its regulatory obligations, that the effect of that would be to, and if the court was satisfied of that, then the effect of that would be to render this alleged contract or transaction unenforceable and potentially to rescind the alleged contract. So, my Lord, that's where we say the documents are relevant.
But your primary case is that this implied term that there would be, for instance, know your own client, taking on board, and so on, and we know that if that isn't complied with, then resulting transactions can be rendered unenforceable.
Yes.
That's the real strength and the heart of your case.
Yes.
Well, look, I'm afraid I'm not going to make this order.
My Lord,
No, I'm sorry, I'm just making my ruling. I'm not making this order. It was refused by the judicial officer. What you should have done was to have appealed. I am not persuaded that this is necessary for the fair disposal of this case. At heart, your implied term looks to those regulatory requirements, the breach of which can render the contract you're sued on unenforceable. And this is not part of the heart of your case. I understand that there was an attempt to amend to bring this into your pleading, but that was not persisted in. And for these reasons, I am not going to make an order in the terms that you have put before the court in 38.2, A, B, C, and D.
My Lord, there is a third category of documents that we see.
Well, look, I mean, how much more time are we doing on this? This was set for an hour and a half. What is this third category?
Well, my Lord, it's set out at paragraph 38.3.
Yeah, settlement of the dispute. Yes.
So, my Lord, just very briefly.
I know your case is that you say that the handling of the trade and the question of settlement was not appropriate. I think you say it was left open, or it should have been left open. Or anyway, you make complaints about the way in which the settlement of the dispute was proceeded.
And the documents provided, or the lack thereof. At
Yes.
settlement, various requests were made for various documents in order to verify the trade.
Right.
And my Lord, again, we say that these are two policies that the claimant general terms that they rely on themselves are referred to therein, the claimant's best execution policy and client handling policy. And we say that these policies reflect whether or not there was fair dealing with the defendants in terms of settling the trade or executing the trade, or the best execution of the trade. And given, my Lord, that the claimants rely on their own general terms and conditions, and given that these two policies are referred in those general terms and conditions, then we find it difficult to understand.
Well, just show me what the request for documents. Where is it in respect of this?
Oh, sorry, I beg your pardon. 38.3, page 17. Of
Yes,
my
but I'm
skeleton.
looking. Where is it? Is the request?
Yes.
Identify with particularity the market which is said give rise to the alleged custom. Is that what you want?
No, my Lord. But if you look at my skeleton argument.
Oh, yeah. I'm sorry. I'm sorry. My fault. I was looking at the wrong thing.
38.3.
Yeah, it's your skeleton argument. Yeah, 33.3.
And page 17, A and B.
17A and B. So you want C's best execution policy,
Which is referred to in its own general terms.
Yes, and you want the client's order.
Which is
handling
again
policy.
referred to in
Yes.
7.3 of the
All
general
right.
terms.
Okay, I understand. Mr. Greenwood?
Yeah, well, we're back really in 38.2 again, actually. This is the internal policies. of the claimant. So I'm making really all the points that I made a few moments ago. This is the attempted duty pleaded case based on breach of our internal policies, and it doesn't arise on the pleading, and it would be irrelevant in any event because whether we were in breach of some internal policy or not is simply not material. So, for all the reasons really I gave in relation to 38.2, I just repeat it in relation to 38.3.
Just give me a moment, Miss Ahmed. Now, just give me a sentence or two on how this fits in with your pleaded case. You've covered the point that in the general terms that are relied on by the claimant, there is reference to these documents.
Yes. Can I invite you, my Lord, to turn at paragraph 22 of my skeleton argument?
22, yes.
Yes, these are part of the facts that were presented and sets out the pleaded case on this point.
Yes.
And it's paragraphs 22 to 23. And there is reference there as to where this is being pleaded in the defence before the court.
Just wait a moment. Well, I can see that as a matter of legal argumentation. I mean, what you're saying is that because of these various failures, certain consequences flow, and you don't need these documents to prove those particular failures. If certain things weren't sent to you, which should have been sent to you, as you say, well, then they weren't sent to you.
Well, my Lord, we say that there would be assistance to the court of having these documents because the probative value would be that the court would be able to assess against those internal policies whether or not the defendants were dealt with fairly, and they say they weren't. And so, my Lord, we do say that there is some value.
You say they weren't dealt with fairly because of these pleaded failures.
And my Lord, those policies would provide evidence of the measure of those failures.
Well, show me in your defence where this is.
What we set out in paragraph 22.
Yeah.
My Lord, it's there in the footnotes. I've footnoted.
Well, I'll take you to the actual defence.
Yes. Defence paragraph 20.
Which tab, which file and which?
So tab 1, volume
File
1,
one. File 1, tab 5. Okay,
yes.
Wait a moment.
So the first
Yes.
one is paragraph,
And paragraph
20.
Yeah, paragraph 20.
Yes.
Yeah.
So the first one is that no admissions are made in any event it's denied that Tavira's anticipations are relevant. No settlement date was communicated to Newpoint until after the 14th of October. That's in relation to the settlement
Yes.
or proof of the disputed trade. Then the next paragraph is 22.2. Sorry, I beg your pardon. Yes, 22.2. That was the first time the claimants received the trade confirmation.
Well, you plead it out here. You say that so far as the defendants can recall, the first time they received the trade confirmation document was the 20th of October.
Yes, but not...
In those circumstances, Tavira is specifically required to prove that the trade confirmation document was sent on the 12th of October. All right?
Paragraph 42.1, my Lord.
42.1.
Yes. Rather, paragraph 42 in its entirety. And this is
Right,
really...
wait a minute.
The entirety of paragraph 42.
Well, I'm sorry, I haven't seen anything in this defence which justifies this request.
Well, my Lord, in the pleaded case of the claimant, they said that they were obliged to close out the position, and we say that it's difficult to understand how that obligation that they've pleaded arises, given that there is no measure of why that obligation arose. And, my Lord, in terms of what we ask for, that in circumstances where the claimant is saying that it was forced to close the position, on what basis does it say that? And we say if we look at the internal policies, that will be evidence of whether or not it followed or complied with its internal policies in respect to...
Well, that's a bootstrap argument about these internal policies. No, I'm sorry, I'm not permitting. I'm just let me finish. I am not going to make an order as requested. This is a plea that arises out of the alleged loss, and you're putting the claimant to proof that it closed out the documents as they say they closed out, and that the consequence of that closing out was that this sum has been lost on the trade on the closeout. And at this particular state of play, the claimant is entitled to say that you must strictly make good, by reference to your pleading, the necessity for these documents, and I'm not persuaded that you've discharged that burden. So I decline to make that order. Now I want the two of you to draw up an order that captures what has been decided in the course of this PTR, so that the registry has a good clean document that shows the outcome. Thank you.
Can I just raise two very short housekeeping points, really? One, we have agreed, you've ordered us to make various searches. Would it be acceptable for us to do that by closing the play on Friday of this week? That's one thing. And then otherwise, I assume the cost in the case.
Yes, I think so. Cost in the case, yes, and Friday for the searches.
Yes.
Thank you.
Excellent. Thank you very much indeed.